Trust me, he knows when microphones go live. Now we got to look up there and see if we're okay.
Okay.
Huh, look at that.
Welcome to Summary Judgment Talk Show. I'm attorney Rachel Baird, and I'm with my co-host Ed Peruta. It's June 15th, Saturday, 2019. We're transmitting live from the American News Media Center in Harwinton, Connecticut. Ed, we have a tight schedule to go through today, don't we?
You've been busy.
But we want to make the announcement first. This past week was the 30th anniversary of the company that you started, American News and Information Services, Inc.
And I'm going to, hold on, I got to hit record. Just hold on.
We celebrated it by posting a poster in the front of the building, and if you go to the message part of our YouTube channel for Summary Judgment Talk Show, you can actually see the poster. It says, "Congratulations, Ed. June 12th, 1989 through June 12th, 2019, and still counting."
Got to remember that officer's name, Joe.
You'll think of it.
Can't remember it.
So, and we're also having a inaugural banquet to celebrate the 30th anniversary of American News, September 21st. Other things we'll be discussing on today's show. Well, we've already discussed that. We're not going to go any further into that.
I just want to say something else. I believe that there is a video stream that is regularly generated, either on, I think it's on Facebook or YouTube, for the town of Kent, Connecticut. And Jeff Parkin has been steadily and repeatedly and faithfully putting out their little board of selectmen to the public. And I think that in September he needs an award.
Yeah, we're trying to think of awards to give out for First Amendment, advocates.
I think that David Warden from News Now Houston needs an award.
So if anybody has any suggestions, J.C. Playford, of course, will be in the mix.
J.C. Playford needs an award.
Not that we've predetermined anything. We're going to have categories of different people and then make a decision. Award. Definitely. So going back, this is our introduction. Update on the Summary Judgment Talk Show search for a social media director. We've had 2 people respond to our post on Production Hub, where we've put out a notice of a social media director for the show after we had some people comment on we're not keeping track of the chat during the shows, we're not responding, and we certainly want to do that, but I think Ed and I are both of a nature where if we start looking at stuff while we're here, we're both going to get too distracted. Do you agree?
I agree.
Yeah, we're kind of like that.
We don't have a very large production staff.
Right. So but we've had 2 very, very impressive candidates, and one's going to be coming up to the show next week to talk to. We're going to do a thank you to our most recent subscribers. We're going to do that every week. Then we're going to get into the meat of the show. We're going to discuss the recent case, Nieves versus Bartlett, how that affects the First Amendment, how that affects a restraint on police in efforts to retaliate against people exercising their First Amendment rights, and what it means to J.C. Playford's case out in the Ninth Circuit.
Let me rephrase that for the other people on the other side of the camera. And I always say that, the people on the other side of the camera. There's a lot of people who subscribe to and watch News Now San Diego, News Now Houston, and people who conduct what we refer to as what has become known as First Amendment audits. And Nieves v. Bartlett could in fact have a negative effect on individuals who do First Amendment audits or simply begin to record police or fire or public safety or government activity.
We're going to get into that.
We are.
Then we're going to talk about a situation here in Connecticut, in East Haven, Connecticut. There's a statute on the books in Connecticut that's been on the books for as long as I can remember, where officers called to testify in criminal and civil proceedings are paid a 50-cent witness fee, and they're paid their travel, but only if they're not compensated by the town. And all of these police officers are compensated by their employer. It's in their union contract. When they come to court, they are compensated fully for that. But there are efforts in East Haven to charge the private duty rate when you call a police officer to testify. And if that were to occur, it would deny people the right to have police officers, to confront police officers, to have them testify in court, whereas it would give the state an advantage because, of course, nobody's going to charge the state for that, but they're going to charge criminal defendants for that. And the town of East Haven has been doing that in violation of the law for years with impunity, and it doesn't seem to matter to anybody, especially to our minority Senate leader, Len Fasano, because he knows all about it and lets it go on. So we want to talk a little bit about that because we received some emails, including State Senator Len Fasano, copied or addressed on some of those emails regarding this situation. So we have a person in the legislature that knows that the law is being violated, but is not only condoning it, but seeking to have a law made post the law, conducting the activities that way to condone what has been illegally done so far. We're going to talk about the new ghost gun law in Connecticut, and then we're going to give Ed a break, right, Ed?
Maybe.
A little break. Health and nutrition segment with Dan and Rachel. We want to talk about some hot issues on that. That's if we have time. Status of the college bribery series. And then thank you for all your comments. People have been commenting and sending them in, and I've printed some of those out. And if we have time, we'll get to those. So, Ed.
Call on me.
Yep.
Say, go ahead.
Go ahead, Ed.
I'd like to make a motion.
Okay.
I'd like to add something to the agenda.
What is that?
Under introduction and list of topics,
Uh-huh.
I think there's two things and they go together. Mm-hmm. I think that it is extremely important that we let the whole country know that the Connecticut legislature has approved contract terms with the Connecticut State Police officers where their disciplinary files are not going to be available to the public under the Freedom of Information Act and will only be made available with a court order. That, together with a recent story that the Connecticut Supreme Court has called the famous Dr. Lee a liar.
Basically, they have called Dr. Henry Lee a liar based on testimony he gave in 1989 that a substance on a towel was blood, when in fact it wasn't blood, and there's an allegation that the prosecutor knew at the time it wasn't blood and said nothing and let two teenagers who were 17 and 18 at the time spend about 30 years in jail. They've recently been the case. That's what our state Supreme Court here in Connecticut has said, and they're returning it to the trial court to be perhaps retried. I don't think that's happening.
Okay, well, let me just, again, confidentiality of state police disciplinary files, Dr. Henry Lee, a liar, and I think that the other 1/3 of that pie is Connecticut does not have a Brady list. When a defense counselor is representing a client, and Dr. Lee's going to come up to testify, either the client needs to know he's a liar, or the lawyer needs to know he's a liar. And I would venture to go on in the future to say nobody's going to announce the fact that he's been found to have lied on the stand. Mm-hmm. And the prosecutors that sat down and let that happen knowingly, nobody is making that known to whatever body regulates attorneys in the role of prosecutor. But I just had to add that onto the agenda. If we get time, we can talk about it. But it is, in my mind,
it's a big deal.
It's huge.
It is a big deal.
It's huge.
Yeah. We have the newspaper over there with the headline, and I'll show the newspaper with the headline later in the show because it's right above the fold.
It is.
Huge news. So we've already covered topics 1 and 2. Want to thank our new subscribers, News Now Minnesota. Did you know there was a News Now Minnesota?
I know there's a lot of news nows, but let me explain something. Mm-hmm. I've been contacted by about between 5 and 10 people who are looking to get involved with First Amendment audits, with credentials, so that when they are in the presence of law enforcement, they can present a set of credentials to identify themselves that I'm not just Joe Shit the Rag Man. I'm here and I'm serving a public service. And I have to figure out, I have to deal with those requests, and I'm going to deal with those requests. So if you've sent your name in and you've explained to me what you do, how you do it, when you do it, there's a good chance that you send me a passport-sized photograph and I will
issue credentials.
And
if you've emailed once and you haven't gotten a response, email again until you do.
All right, now,
that's the secret.
Just to let Master
We're
Control,
not ignoring you.
Just to let Master Control know, I think we need to tweak the green screen background.
Yes.
Because it's starting to staticky.
Yes.
So he knows how to do that now under Upstream 3. So.
What? He said something. What? Okay. Okay. Oh, J Moore Pranks, Samala 5793, Jonah Christo, Jeannie Michelle Phillips, Dark Junebug, FLA Miami, Chris Carr, Brandad 101, My Guns Burst. Thank you for subscribing recently. We're going to do that every week. Let's get to it. Let's get to the meat of this. Nieves versus Bartlett. Why don't I have the case on my... Here, I'll bring it up here. Nieves versus Bartlett is a case that was decided, I think, on May 28th of 2019. It could have been the 27th or the 28th.
Within the last 30 days.
Within the last 30 days. It was argued back in November of 2018. It was decided, of course, by the United States Supreme Court. You know, I got to get that decision, Ed, because I made notes on it.
Well, so, go ahead. Let me see if I can go off the cuff a little bit here. It's my understanding that the decision was broken down into 4 areas.
Yes, A, B, C, and D.
A, B, C, and D. And what happened was, and in order for it to be rendered positively, they needed 5 votes.
That's a majority, 5 out of 9.
5 out of 9.
Mm-hmm.
And in Part D, I'm not pleased with A, B, and C, but I can understand why the Supreme Court may have ruled the way they ruled.
Oh, no, I don't.
No, well, okay.
I would not say that at all.
Well, let me put it this way. There seems to be a strong majority of the court who affirmed and confirmed and supported the exemption under certain circumstances to the elements that were addressed in A, B, and C.
Well, let's break it down. Chief Justice Roberts.
I got him.
Justice Alito, Justice Kagan, Justice Breyer, and Justice Kavanaugh were the 5-member majority who wrote the decision in 4 parts. And the first 3 parts basically say, if there's probable cause for the arrest, you cannot sue for retaliatory animus under the First Amendment.
Regardless of whether the probable cause came first or second.
Right.
If there's probable cause to arrest, it's gonna be upheld.
Yes.
Okay, got it.
But then there's Section 4.
Right.
And again, these 5 agreed on Section 4, which is actually Section D.
Well, let's put it this way. Obviously, Roberts, Alito, Kagan, Breyer, and Alito approved the entire opinion of the court.
Yes, A, B, C, and D.
So that's 5.
Yes.
Right?
Yes.
5 or 6?
5.
5. Okay. And Clarence Thomas was against D. The 4th section, D.
The 4th section provides an exemption. In other words, the first 3 sections basically say probable cause defeats a First Amendment retaliatory claim. But then they go to Section 4 and they say, except under these unusual, egregious circumstances.
Okay, now
there's an exception.
Now let me. Is the word egregious and unusual in D?
No.
Okay, so do me a favor.
Yeah.
Don't put egregious and unusual as a requirement to get to fall into the exemption.
Yeah, I think that's
the reason being.
The way it's going to be.
The reason being, with everybody that's out there with cell phones,
right?
With everybody out there, the News Now this and the News Now that, and everybody else doing these others, it's not unusual anymore.
Right.
Okay. So, and it's not unique. I mean, there are cases, shootings, riots, etc., where members of the public are capturing the activity taking place on a recording device, cell phone, camera, audio recording, whatever. So that's no longer unique. But the court, in Part D of Nieves v. Bartlett, set out some parameters, some kind of broad parameters. They're kind of broad.
Yeah, but Ed, you have to read Justice Sonia Sotomayor's dissent. She dissents from the entire thing. She says that you don't need probable cause to bring a First Amendment retaliatory claim. And she says under what the court has done, it's going to be almost impossible to prove retaliation because you're going to have to show that other people were doing the same exact thing as you, but because you were exercising your First Amendment right, you were retaliated against. In how many circumstances can you show that other people were doing the exact same thing as you?
Okay.
She says maybe in a protest. You know, but it's going to be very difficult. It's like selective enforcement. It's hard to prove selective enforcement claims because you have to find other people who were subject to the exact same circumstances you were, but weren't prosecuted. It's almost impossible.
All right, so
it's a terrible decision.
Let's get into the deep and nasty. I believe it was May 25th, 2012.
No, I think we should talk about the case. We haven't finished talking about the case yet. So 5 justices.
It's time to make a statement.
Okay. Read the case yourself.
If you are going to be recording and there are other individuals around you recording, make sure that you record the other people who are doing exactly what you're doing and are not being arrested. That is, and get their names if you can. You know, go up and ask them. But usually you're in handcuffs being transported to headquarters to be processed and you don't get to do that. But what I'm saying is, document what's going on before law enforcement comes up to you. Now, go ahead. I needed to interject that at the time you were talking about it because there's a lot of people who watch News Now San Diego, News Now Houston, News Now Minnesota, whatever.
Yep.
And they need to understand that David Warden knows what he's doing. And J.C. Playford knows what he's doing. And when I'm out there, I know what I'm doing. I'm not a novice to it. I got 30 plus, probably 45 years of doing it. And some people are going to get jammed up by law enforcement because they don't know how to address the situation as it's unfolding.
They give an example in the case where it says, at many intersections, for example, jaywalking is endemic, but it rarely results in arrest. If an individual who has been vocally complaining about police conduct is arrested for jaywalking at such an intersection, it would seem insufficiently protective of First Amendment rights to dismiss that individual's retaliatory arrest claim on the ground that there was undoubted probable cause for the arrest. In such a case, because probable cause does little to prove or disprove the causal connection between animus and injury, Applying Hartman's rule would come at the expense of Hartman's logic. They're referring to a previous case that they were decided.
Yeah.
I don't think it's that easy to prove that an officer would not have arrested somebody for jaywalking at that intersection. How are you going to compilate proof that other people were jaywalking and did not get arrested, but you were, unless there were 15 people jaywalking at the same time as you, and you got arrested and nobody else got arrested, and you can prove that those other people hadn't been vocal about the police and you had been vocal about the police, and so there you have a claim. Otherwise, it's going to be really hard to prove.
Now, let me say what you said and what the court was talking about jaywalking in the way I would explain it. Okay? There is probable cause to arrest Johnny Jones for jaywalking because he was observed jaywalking.
Right.
Without a doubt. Johnny Jones walked diagonally across an intersection and didn't stay within the crosswalks to get where he was going to the other side. Fair enough? Okay. Now, the one difference, and what they're saying is, the officer's standing there. He sees 100 people jaywalk. And he stops no one, he detains no one, he questions no one, he warns no one, he educates no one. But all of a sudden, a person known to the officer for breaking curfew 100 times previously is seen jaywalking through the intersection. And because he knows that person, and he's pissed that that person has never been fined or convicted of breaking curfew, he says, fuck you, I'm going to stop you. He doesn't say it, but in his head he goes, I got him. Because he's on camera.
Mm-hmm.
I'm going to give him a ticket for jaywalking. That is where the claim can be made under this exemption of retaliatory detention, arrest, or whatever.
Right.
Because the officer had prior contact or knowledge of the person who was jaywalking and was frustrated with that person socially, public safety-wise, or whatever, and said, now I got it.
But that's not First Amendment retaliation.
But it is retaliation.
It's no.
Well, jaywalking isn't First Amendment. But what they're saying is
No, Ed. There's no constitutional right to be free from retaliatory arrest under the first. That's a due process claim. That's an equal protection claim under the 14th Amendment. What they're saying here is that the person has been vocal about police misconduct. The person has videotaped the police. And on this one particular occasion, I see this person jaywalking, and I'm going to give him a ticket because of this First Amendment activity he's done in the past.
Right.
We're just talking about retaliation for First Amendment activity right now.
Let me rephrase it. He continually voices his displeasure with the activities of law enforcement and the way they conduct themselves.
And let me tell you why this is going to be so hard. And let's use J.C. Playford as an example, the May 25th, 2012 incident you were bringing up. J.C. Playford was at an accident scene, right?
Right.
Way back, not right close to it.
Way back.
And there was a perimeter, and a reporter from the Union Tribune was on the inside of the perimeter, Karen Brainerd, correct?
Correct.
Okay, so J.C. Playford wanted to be inside the perimeter as media to get footage or to get information about the accident, right?
Right.
J.C. Playford started making a stink about it, right?
Right.
I'm the media, let me through. They arrested him, right?
Right.
For interfering with an officer. He was later found not guilty. Now, when we use this as an example of a First Amendment retaliation, his arrest, what the trial court did in the District of San Diego, was the Southern District of California, said, I'm going to throw this out. I'm going to grant summary judgment for the county because even though he wasn't convicted, there was probable cause. He was interfering with the officers. When he was speaking and doing all this, they weren't paying attention to the accident. They were paying attention to him.
Right.
In that case, how is JC going to prove that others similarly situated to him would not have been arrested because there was no other media there making a stink? Okay, Karen Brainerd wasn't because she got what she wanted. J.C. Playford was the only one there protesting because he could not cover the incident. So how is he going to get this evidence that there was anybody similarly situated to him making a stink about not getting through when there wasn't? Do you see the illogic of this argument? In other words, if your First Amendment rights are violated and you protest it, well, that protest becomes interfering with an officer, and so there's not going to be anybody else that did the same thing as you in protesting it. So you're never going to find somebody who's similarly situated to say it was retaliation. They're going to come back at you and say it wasn't retaliation. It's because you spoke up and you protested and you challenged him, and you can't prove that anybody else did that exact same thing. And so your case is thrown out. That's what I'm worried about.
Maybe I read it wrong.
Okay.
Maybe I read it wrong.
Well, it's a new case. We're discussing
because I went and created a list after reading.
Yeah.
And it goes like this. And I'm going to talk only because this decision began in the state of Alaska, found its way to the Ninth Circuit Court of Appeals in San Francisco, and then found its way to the U.S. Supreme Court.
And the Ninth Circuit ruled in favor of Bartlett, the gentleman that was arrested.
Right.
Okay.
Now, in the Bartlett arrest, there was a large event where everybody seemed to be drinking and possibly intoxicated.
Called the Arctic Man Festival.
Right. And Mr. Bartlett began to verbalize to the people being questioned by law enforcement not to answer questions.
Right.
And telling law enforcement you can't interview them because they're juveniles. And this went on, and Bartlett was eventually arrested. And Bartlett is alleged to have been drinking. Possibly intoxicated. I don't know. Doesn't matter to me. And the case began to work its way through the federal courts. The charges against him were dismissed, and he started to work his way through the federal courts in Alaska, then to the Ninth Circuit, then to the Supreme Court. And I think that they clearly said, Bartlett didn't know who this guy was. How could he have any animus against this guy?
Well, the two officers, Nieves and Officer Waite. Officer Nieves and Officer Waite did not know who Bartlett was.
Right. And the decision references one statement made by either Nieves or, who's the other officer?
Waite.
Now you should have listened to what I said to you.
Right.
Now do you wish you listened to what I said to you? Which meant that when they made the arrest, they were basing it on him continuing to exercise his rights to freedom of speech while he was told to stop. Okay, now, so I'm going to read, because J.C. Playford comes out of the exact same Ninth Circuit Court of Appeals. It's there.
Before you do that, let me read exactly what the exemption is. Okay?
Go ahead.
And then you can compare it to what you're going to say.
And I'm going to write them by number. Get a pen, everybody. 1.
We conclude that the no probable cause requirement should not apply when a plaintiff presents objective evidence.
Objective evidence.
That he was arrested.
Oh, we got that.
When otherwise similarly situated individuals not engaged in the same sort of protected speech had not been.
Okay, now
see what
stop
I'm
right
saying?
there.
How
Stop
hard
right
that
there.
is?
Stop right there. Read it, and when I ask you to...
If you're arrested for protesting, obviously nobody else is protesting,
Well,
so you're not going to be able to prove that they were protesting.
Let me ask a question. did we argue, and did we include in Playford that there was that there's evidence that he was arrested? It's on camera. Okay? And was there anyone else there in a similar situation, and I think you said who did not get arrested, did not do it and did not get arrested? Read it, and that's Karen Brainerd.
Well, did J.C. Playford get arrested because of what he said or because of what he tried to do?
Okay. J.C. Playford gets out of his car a half a mile from the accident and begins to walk because they're stopping all traffic. He begins to walk towards the incident. Deputy Proctor, over the county sheriff's radio, calls down to the scene and said, Playford's on the way. So they know now that Playford's coming. And up until that point, Deputy Brenneman, who was at the scene, supporting the state police, the highway patrol, because they had the accident, it was their accident, begins to hurry up to put a yellow tape across the road. And we maintain because Playford is coming. JC gets to the tape and is told, you can't come in here. And all the time, JC Playford's camera is capturing North County Sentinel, the Sentinel reporter, photographer, Karen Brainerd, walking right down the side of the road towards the accident scene in the area which Brenneman has taped off to prevent JC from getting into.
Okay, that's good stuff.
Now, and that's in the complaint.
Yes.
And we have the video.
Yes.
Now, JC begins to argue with Deputy Brenneman, saying, you can't do this. I have a right to go down there.
And I guarantee the county, because I think June 24th is the deadline set by the Ninth Circuit for me, on behalf of J.C. Playford and American News, and for the county, on behalf of, the Sheriff's Department and the deputies, to write no more than a 10-page brief to the Ninth Circuit about whether or not Nieves versus Bartlett applies to J.C. Playford's situation, and if it does, then how does it?
Okay, now, let me just wrap it up, and then I'm going to read what I've got here. So,
but I'm not done reading.
I know. Yeah, I'll let you read.
Right.
J.C. Playford has walked down to the scene. His presence has been announced to the people at the scene in the Sheriff's Department. And he's having an argument or discussion with Deputy Brenneman about why he should be permitted in. And a highway patrol sergeant comes up, Nielsen. It's his accident. And he is approached by Deputy Ainsworth, who says to Nielsen, the highway patrol, he's not the media. He's not the media. Meaning she is, he's not. He can't go in because he's not. We claim that. We claimed that American News media credentials should be given the same weight and recognition as county-issued or government-issued media credentials. Now, you want to keep reading, but I got a list.
So far we've established that the exemption applies when there's objective evidence that a person was arrested when otherwise similarly situated individuals
Otherwise similarly situated individuals, that's Karen Brainerd.
Not engaged in the same sort of protective speech.
She did not engage in it, and she didn't get arrested.
Good point, Ed. I agree with that.
Okay, so that's the Karen Brainerd evidence.
I agree with that.
Go ahead. So we've passed the first criteria. Go ahead.
This provides, that's basically the criteria right there, that one sentence. And then the court goes on to say, This provides an objective inquiry that avoids the significant problems that would arise from reviewing police conduct under a purely subjective standard. In other words, if you're jaywalking and you're given a ticket, and while you're being given the ticket, the police officer says, "I'm giving you this ticket because," well, I don't know if that's
you go
a
to
good
the
example.
police commission and complain too much.
Right. But if he's
That's Lozman.
But if he's given other people tickets as well, that's objective evidence that
He was doing it to everybody. He
that he-
just got caught up in it.
In other words, yeah.
Okay.
And so I feel like I have to go real fast because you want to get to your thing. So go ahead. We already
Okay.
stated this.
All right.
Go ahead.
For everybody on the other side of the camera that conducts First Amendment audits, whatever state you're in, whatever county you're in, whatever community you're in, with whatever law enforcement agency operates within that area, watch this. Now, you just heard Rachel read the exemption to being able to file a claim to a Supreme Court decision that says you can't. But there's this one exemption. And here's why J.C. Playford falls into it. The facts of the case currently before the court clearly fall within the narrow qualifications stated where members of the San Diego Sheriff's Department and other law enforcement personnel exploit their powers of arrest by stopping and arresting J.C. Playford while regularly permitting other private individuals and approved members of organized media organizations to access, view, gather facts, photographs, and video at public safety incidents. Can we agree on that?
Mm-hmm.
Okay.
Definitely.
The El Cajon courthouse, where they closed the door. It's a news conference. They let everybody else in, but they wouldn't let J.C. Playford in.
And this is where we kind of get into the Lozman territory.
Exactly.
Are you going to mention that in there?
I'm okay. Here we
Okay.
go. The facts and elements in this case clearly present objective evidence that the May 25th, 2012 arrest of J.C. Playford on California State Road 67 took place while a similarly situated individual, Karen Brainerd, was being recorded while she was permitted to engage in similar protected news gathering activity. Unlike Russell Bartlett, Mr. Playford went to trial on the May 25th arrest and was found not guilty. Bartlett's case was dismissed. He never went to trial. They made J.C. go to trial. And it came out, the meat grinder, with J.C. not guilty. Unlike Russell Bartlett, Mr. Playford was well known to members of the San Diego County law enforcement agencies and their sworn personnel. Unlike Russell Bartlett, Mr. Playford had not been drinking. Unlike Russell Bartlett, Mr. Playford was in possession of privately issued media credentials issued by American News and Information Services, Inc. Unlike the state of Alaska, the state of California has a section of law which addresses media access to public safety incidents. Now, San Diego Police Department and San Diego Sheriff's Department have media policies. And their media policies authorize the San Diego Police Department, in behalf of all law enforcement agencies in San Diego County, to issue media credentials to the people that pass their test or pass the qualifications that they've established. They also give them, and this goes to Jerry Nance, they also give a parking placard which you can put on your dashboard and illegally park during an incident. Okay. J.C. Playford was issued media credentials. They were revoked. They were reissued. But the argument that we made in the federal courts in California and the argument that is currently before the Ninth Circuit Court of Appeals is this. Why are they not recognizing American News and Information Services credentials and giving them equal status to some government card or piece of paper that's given to you? Why? Why are our credentials no good? We recognize and determine who our representatives will be to represent American News. Government can't tell me who to give it to. Government can't tell me who not to give it to. David Warden has a set. J.C. Playford has a set. And there's some other people out there. North Georgia, they have a set.
I have a set.
You have a set? Okay. Denial of or revocation of media credentials or recognition to individuals who have the ability to diminish the government's narrative of the events is being covered. To diminish the government's narrative of events being covered. In other words, when there's an incident, law enforcement wants to be able to go back to their report room, sit down at a laptop, and type a report. And they want to put facts in to their report that will not be challenged by any third-party evidence. They don't want you taking pictures because they look at Baltimore. The body camera caught him planting drugs. Look at the shooting in South Carolina where the officer said, oh, he had a gun. And then a week later, somebody says, I got cell phone video. He didn't have a gun. Okay? All right. The media policies and practices of the San Diego County Sheriff's Department, San Diego Police Department, and other government agencies in San Diego County. Because it also talks in here about, are there policies?
Is there a municipal policy?
Is there a government policy, not just municipal? Is there a government policy that somewhat contributes to what happened?
Well, you can't sue states under 1983, but anyway, go ahead.
Okay.
Well, for damages.
The preferential treatment of media organizations and personnel who do not question or challenge unlawful orders or restrictions imposed at public safety incidents. I have a video. It's up on YouTube. I was in the city of New Britain, Connecticut, and a police sergeant picks up my fucking camera and tripod and starts walking away with it. At the time I arrived at the scene, WVIT Channel 30's crew was probably 500 feet down the road at an intersection, and there was a piece of yellow tape across the road. I walked right past them, walked right up to the scene, because I'm not going to be in the crime scene. I'm not going to be in an evidence field. I'm not going to be in a debris field. I'm going to just be on a public sidewalk, and I'm going to start recording what's going on. And I was told that I can't. But that full-time brick-and-mortar camera crew would not challenge a police officer telling him, stay where you are. Aye, aye, Captain. All right. The failure to recognize and give equal treatment to privately credentialed individuals who respond to scheduled and unscheduled newsworthy incidents. There is video up on News Now San Diego back 2010, 2011, where there was going to be a news conference at the district attorney's office. J.C. Playford, with American News media credentials, goes upstairs, gets off the elevator. He's going to go into the news conference. And there's a sign that he captured. Only people with San Diego media credentials are permitted. Well, JC's smart enough to know, wait a minute. Why only them? Why not me? I may have a different editorial opinion. I may have some information that I'm going to ask questions about that you don't want anybody to know about, but I'm going to ask you questions. JC has a habit of doing that. like Lozman. The countywide agreement between government agencies to issue and recognize media credentials issued by the San Diego Police Department. Now, I don't know if we put it into the complaint, but one of the arguments would be this. J.C. Playford has a female highway patrol captain on video asking him for his California Highway Patrol media credentials. Again, 2008, 2009, 2010. She's asking him, where's your state police, where's your CHP media credentials? J.C. Playford's smart enough to say to her captain, CHP, California Highway Patrol, stopped issuing media credentials for exactly the reasons I'm talking about here. Is they decided not to get involved in saying who is and who is not the media. Not our job. Right. Now, in the state of Connecticut, back in the 1980s, the Connecticut State Police used to issue media cards. And a local weekly newspaper in Hartford, Connecticut, called the Hartford Advocate, and it was one of those, people were looking for sex in the classifieds, and they had all kinds of crazy stories in it. But it was a weekly, not a daily. And the state police said to the Hartford Advocate, oh no, we're not giving media credentials to your people. Why? Well, because you're a weekly, not a daily. We're not giving them to you. The Hartford Advocate threatened, probably with the assistance of the ACLU, to sue the state police over the issue of trying to say who is and who is not the media. Guess what? The Connecticut State Police stopped issuing media credentials long before it was done by the California Highway Patrol. They said, we're getting out of this. This isn't supposed to happen. Now, well-publicized credential confrontations between James Playford and various members of the San Diego Sheriff's Department, San Diego Superior Courts, San Diego District Attorney's Office, and San Diego Police Department, El Cajon Police Department, and others. It's well documented. So, I know that we didn't put it in the complaint, that J.C. Playford is now being told that they are actually using some of American News clips shot by J.C. Playford at the training academy to train members of law enforcement in how to respond to people like J.C.
Let me just add in there, from a procedural point, we filed this complaint in 2012.
We did.
So a lot has happened factually to JC in the past 7 years that obviously is not included in the complaint because it was written in 2012. Now, in Nieves versus Bartlett, the case was thrown out on summary judgment. Now, when a case is filed, often the defendant will file a motion to dismiss. They'll say, you fail to even state a claim. And for that reason, it should be dismissed without even any depositions, without discovery. Just throw it out right now because it doesn't state a claim. Even if everything in your complaint were true, you don't state a claim. And that's what the judge in J.C. Playford's case said. He said, because I think there was probable cause for your arrest, you fail to state a claim, and so it's thrown out because probable cause defeats a First Amendment retaliatory claim. The judge in the district court took the, black and white view. Probable cause, no claim. At least the United States Supreme Court has provided an exception. The only justice to agree with the judge in J.C. Playford's case is Judge Clarence Thomas. Judge Clarence Thomas takes the position that no matter what the circumstances are, if there was probable cause, then you have no claim. There's no exception to that.
Well,
so Justice Thomas was way over here, And then you have Justice Sotomayor over here that says probable cause or not has nothing to do with whether you have a claim or not. If that police officer violated the First Amendment, you have a claim.
Okay, so let me see if I can get this straight. Okay? You're going to file a 10-page brief, 10-page document that's going to set forth why Lozman applies and Nieves does not.
Yes, basically.
That's what you're going to do. And you could,
or I could say Nieves applies because the exception in Nieves applies.
Right. Now, so let me,
right.
We had a discussion about this yesterday.
Right.
So I think that the Playford case in the Ninth Circuit leans more towards Lozman with the protections of Part D of Nieves. Okay? The exemption from Nieves clearly puts JC over under Lozman.
It's two different
He's
things.
got all of the criteria
but it's
of Lozman.
two different things. Lozman is a municipal policy or procedure, and JC falls under that. Nieves is whether he can show objectively that similarly situated persons it would not have been arrested.
Right. So let me...
So it really is two parts.
I can wrap this up very quickly because I've done a lot of thinking about this. And I'm not the lawyer, but here's what I suggested. In the preamble, the first paragraph of that 10-page document, you clearly set out why the exemption in Nieves applies to American News and Playford. You do it now. Goes like this. We know that Justice Ginsburg was absolutely adamant that this is a bad case, should never have been brought because it may affect the media.
Well, there are cases where if you want to, get a certain decision that are better on the facts than other cases. For example, let's think of, Heller and McDonald.
Yep.
The NRA or Second Amendment Foundation, whoever chose the plaintiffs in those cases, chose them for a reason.
Right.
Because courts would be more sympathetic to these people.
Correct.
And in this case, this is a terrible case to have had this issue decided because Bartlett is not sympathetic. He doesn't claim to be the media at the time. He's not claiming any First Amendment right at the Arctic Man Festival. He's supposedly maybe had been drinking. And I'm not saying he doesn't have First Amendment rights, but if you want to get a decision on the scope of First Amendment rights, he's probably not the person to get it on.
Okay.
And so
when I read
this, what Justice Ginsburg says.
I was going to just say.
Yeah.
Very short. Tell me how Ginsburg said it.
Yes. She says, in any event, I would not use this thin case to state a rule that will leave press members and others exercising First Amendment rights with little protection against police suppression of their speech. In other words, she's saying, based on what Bartlett did, that's going to affect people out there that are attempting to gather the news and hold the government accountable.
Now, let me continue with what I was going to say.
Good.
Okay?
Yep.
I know of no other case in the country that has all of the elements of Playford that clearly Justice Ginsburg is going to say, that's the situation I was talking about. Who knows? They may already know about it. But they're going to sit there and say, this is the case that makes the Nieves case crazy or too narrow. Now, so that's Ginsburg. That's one. Now we're going to go to Sotomayor.
Oh.
Sotomayor is going to see the case come in.
Well, let's take a phone call. We've had a number of phone calls come in.
Who's on the phone? We know?
Joe from Chicago.
Oh, Joe from Chicago.
And maybe if the other people could call back, we'll take calls now since we're taking a break. Yeah.
Hold on a minute, Joe. Hold on a minute.
It's okay.
But that's going to start making. See if you can hang up line 2 out there. If we lose you, call back. But I'm going to try. I'm going to try and get rid of line 2. Will start beeping pretty soon.
Well, he'll get rid of it, Ed. Let's just start.
Okay, you there?
Yeah, it works whenever you do.
Okay, good.
How you guys doing? Ed, you look really good, man. You look like you put on a couple pounds. You look really healthy, bro.
I fluctuate 4 or 5 pounds during the week.
Thank you, Joe. Thank you for saying those nice things.
Now, Joe, just to let you know, last Tuesday, I had to go into a surgeon's office and sign papers to give him permission to take the heart out of my chest.
And put another one in.
And put another one in.
Wow.
So I went on to the heart transplant list last Tuesday.
So what do you think about this decision, Joe? Were you familiar with it before today? Had you?
No, I just caught the end of it. I just woke up, and I was just thinking, these guys are brilliant, man. You guys, I'm usually familiar with some of these, cases. I was not familiar with the ones you guys were talking about. I thought that was, you guys articulated super well, right, with Sotomayor on one end and Thomas on the other. No, I'm not familiar with the case, but you know which side I'm coming down on. Rachel called to say thank you, and JC not stopped erasing your videos. Said started putting them on YouTube, kind of for storage, hoping nobody even saw. Somebody saw it. They told Big Nick. I woke up with like 2,000 subscribers and I don't know how many thousands of views and all of that. So the channel taking off, man.
What?
And, it's called,
Oh my God!
I gotta have at least 4,000 subscribers, man.
You got more than we do.
That's great. That is good, because what you're doing needs to be out there for people to see, because that's the whole reason we do it, right?
Right on, absolutely. The best thing about this that I see so far is talking to the people in the comments. I didn't think I'd be able to communicate with so many people, and just exposing the police for just being disrespectful and how they treat folks around here totally different, breaking laws left and right. So I don't know, something in there though. People are digging. Just thank you. I don't want to take you guys on a roll.
I need to talk to you.
Well, I feel so inspired by this phone call.
I need to talk to you.
Okay, yeah, I need to find one of the videos too. I wouldn't know how to find them. The channel was under Joe Cool. I never looked for it, but a lot of other people have found it.
Okay.
You guys need to check that out one day. What do you want to wrap it up?
Here we go. I'm gonna give you information. If you've already got it, you've got it.
Okay.
You have over 1,000 subscribers, correct?
I do, yeah.
All right. And I believe you have to have so many views
Yeah.
in the last 30 days.
350,000 at least, for sure.
Well, what I'm saying to you is, are you monetizing your videos?
I haven't made a dime. I don't even know how to do that.
Just stop. There is a program, and YouTube is YouTube, but then there's something called YouTube. It's on my phone. YouTube. Hold on a minute. YouTube Studio. It's a program. It's an app called YouTube Studio.
I've downloaded it, but I haven't done anything with it. I was told I needed to download it, and I did, but I don't know what to do.
If you research on YouTube monetization, they will tell you how to monetize your channel. Where the little advertisements come up and then it says after 5 seconds, skip the ad.
Right.
But it'll take time, but you'll slowly begin to make revenue from the things that you post on YouTube.
I don't think it's going to take Joe much time.
No. But what I'm saying is, I'm trying to tell you that there is in fact a way for you to, if you meet the minimum qualifications, to generate revenue by monetizing your channel.
I am writing it down right now. I wrote it down. Yes, I
Yep.
get on top of that. Yes, I am. a kid came over yesterday and set up a PayPal for me.
Yep.
So,
Set up a PayPal,
yeah.
and then you have to have what's called an AdSense account.
AdSense?
ADDSENSE. AdSense.
Oh.
Gotcha.
Did I spell it wrong?
Just one D.
AD. Okay, AdSense.
Okay.
I am looking at your YouTube channel, and I have counted 13 videos. 15,
All right.
15 videos, excuse me. And one of those videos has 183,000 views.
No, it can't be a week old.
Yeah, 2 weeks, 183,000
Okay.
views. And you have 4,100 subscribers.
And
That
I think,
is
and
crazy.
now let me ask you a question. Did I ever give you a set of media credentials?
No, I did not get one. But I wish I'd have been wearing a hat on the fucking videos. Right?
Okay, here's what I'm gonna do for you.
Yeah, we want a part of this.
Here's what I'm gonna do for you.
We want to be involved.
I'm gonna send you, Joe.
Thank
Hold
you,
on.
Greg. If you've been watching the channel, I've been thinking you left and right.
Now, do you have an afro?
I do not anymore.
Okay,
Yeah,
listen. Then this hat will fit your head. Okay? You send me all of your information
Okay.
plus a photograph. Stand up against the wall, have somebody take a photograph. Have somebody take a photograph, and I will issue you a set of American News media credentials, and you'll become part of ANUS.
Yes, I'm down with that. Yes, okay. I'll take the square picture, man, and put on those. I'll put those square pictures on your show, though, man. Don't put no square stuff on that.
Thank you so
You know
much for
something?
calling in.
Hold on a minute. 30 days ago, how many videos did you have posted?
None.
Wait a minute. And how long have you had this YouTube channel?
I'd say about 9 or 10 days.
And you've got 4,100 subscribers.
Everybody is calling me saying it's a lot, but I've never looked at views. I have to take people's word for it. I still haven't looked at other people's views and stuff. I don't know how many views
Hold on a
you
minute.
guys got.
Are you?
So people are telling me it's a lot. That's the only way.
It is a lot. Now, do you understand what the part of YouTube that says analytics?
Oh, let's
No,
hold
hold on. No.
I don't know nothing about
Okay, listen
this,
to
but-
He's
me.
got enough information.
You know something? You know how to.
Yeah, this will keep me down
Yes.
all week just trying to figure this out. Yeah.
You know how to get a hold of me. So
Oh, yeah, good,
my
yeah.
my suggestion would be you get a hold of me because you need a set of media credentials. You need a hat that says news media. You've got the
Right.
YouTube channel. You're now starting to build your subscriber base.
Well, let's qualify that. He doesn't need media credentials. Nobody needs
No.
media credentials.
I would like him to, I would be proud
Yes.
to have a set of media credentials running around Chicago.
Yes,
That's how
definitely.
I feel about it as well. I don't need that shit, but I gotta work. You old Republican white Catholics affected me. I gotta work you in somewhere, Jack. I'd be proud to wear them damn credentials. Yes, I would.
Well, I'm glad you woke up and called in. Thank you.
All right, look. I don't want to take your time, Ed. I'm gonna give you my email. I want to try to get with you on the phone so you can walk me through some of this stuff.
I'm going to put you on hold. Dan will pick up in master control and he'll write it down, okay?
All right, great.
Okay.
All right.
Put you on hold now.
Okay.
Where's hold?
We're going to get Joe's email.
Okay.
Okay.
I am absolutely amazed,
Amazed.
but I am very proud
Yes.
of the fact because, it goes back when Dave Warden and I were first talking. And I suggested, News Now Houston, get yourself a Twitter, get this, get that. Now, he's had his issues, but Dave Warden is a very resourceful individual. And I still support David Warden and News Now Houston and whatever endeavor he may be in to expose what he's doing.
I'm just thinking about Joe and his subscribers, the over 4,000, and then all the views that he gets, and how many people he's inspiring now to go out and do the exact same thing.
Exactly.
That's what I'm thinking
Exactly.
about.
I mean, I can remember January of 1987, I went to a fire. I was a fireman. But I also took pictures when I wasn't at the fire, when it wasn't my department that was putting it out. And I had to get out of my car, put my turnout gear on, and go in and get people out of the building. And there was a kid standing next to me named Mike Martino. And I gave him my still camera and flash. And I said, do me a favor, it's all automatic. Just start taking pictures. And Mike Martino, shit, that's what, 39 years ago, 30-something years ago, 32 years ago?
32.
32 years ago. And Mike Martino went on that every time there was an accident in town, every time there was a fire in town, he had the history of Rocky Hill, Connecticut's public safety on film, in a camera, and he wasn't using digital. He was still doing the, and you go into restaurants in Rocky Hill, they're his pictures of the ferry, of the town hall, and everything. And I felt so proud that I put the camera in his hand the first time and said, do it.
I want to get back.
To the schedule.
No, not to the schedule. I want to get back to Justice Sonia Sotomayor.
Then let me just finish what I was saying.
Because she is my heroine.
Let me just finish what I was going to say.
I've been looking for a cardboard cutout of her on the internet to put in my front window, but I've not been able to find it.
I believe that Justice Gorsuch, Sotomayor, Ginsburg are going to look at because no matter what happens in the ninth, if the San Diego is affirmed, the decision is in San Diego's favor, we're going to ask to go to the Supreme Court. If we win, I'm sure they're going to ask to go to the Supreme Court. But what I'm saying is, if in that preamble, when it comes into the clerk,
they may not.
When it comes into the court, and some clerk for Justice Ginsburg or whoever reads the preamble and you're referencing, this is why this case needs to go forward, is because of the exemption set forth in Nieves. Somebody up down in Washington is going to go like this. This is the case. This is it. And you got to understand something. I'm not aware of any other case in the country that has the elements of Playford to fall into that exemption in Nieves. That's that close to the Supreme Court door.
The person that argued Nieves versus Bartlett on the side of Bartlett, the gentleman who was arrested, was a Professor Carlin, Karlan, I believe her first name's Pamela, from the Supreme Court Litigation Clinic at Stanford Law School. So what this Supreme Court Litigation Clinic does is an attorney may have a case that's a important case when it comes to making constitutional law or preserving rights, whatever. And the Supreme Court Litigation Clinic will pick up the case and help the attorney with it, take it over to a certain extent perhaps, because they have the resources, the experience, the students at the law school to put 500% into it, And Professor Carlin not only argued the Bartlett case, Nieves versus Bartlett, which, let's face it, there's a lot wrong with that case that didn't come out the way First Amendment advocates would have wanted it to come out. But she also argued feigned Lozman versus City of Riviera Beach, Florida.
Lozman too.
And she won. She won that one, where they said probable cause does not defeat a First Amendment retaliatory claim under certain circumstances.
Is there any way we can get in touch with her?
So she has argued both of the most recent First Amendment cases at the Supreme Court. And so I reached out to her.
Oh.
And if anybody knows her in California, if anybody, or anywhere, but I would assume maybe some people in California know her. I wrote to her and I said, first of all, thank you for your work, advocacy, and dedication to the First Amendment issues presented in Lozman and Nieves. We received an order last week from the Ninth Circuit stating the parties are ordered to file supplemental letter briefs of less than 10 pages as to the effect, if any, of the Supreme Court's decision in Nieves versus Bartlett. on this appeal within 21 days of the order, and that order came out on June 3rd, so we have till June 24th. I said to her, my impression is that our case, American News v. Gore, is positioned between Lozman and Nieves with more similarity to Lozman. I said, I cannot imagine how many emails you receive similar to this one at your clinic, but I still write to ask if you and the clinic have interest in further presenting American News to the Ninth Circuit. Obviously, your involvement would exponentially increase our chances of prevailing and protecting the sliver of First Amendment rights at stake, addressing what Justice Ginsburg said and the effect of this terrible decision in Nieves with the one shining point of the exemption. And I haven't heard back. They're busy. I sent this on June 11th, but I'm keeping my fingers crossed that they will review this and find some interest at the clinic in helping us out on this.
Well, obviously, the Ninth Circuit is looking at that exemption.
Yes.
And they're aware of American News v. Gore. And they're probably sitting there saying, we're not going to render a decision without giving them an opportunity to present the facts for an exemption.
Just getting back to what I was talking about, the motion to dismiss, my point was, in my opinion, at the least, we should have the opportunity to go back down to the Southern District of California, and our retaliatory First Amendment claims were thrown out on dismissal. We should be able to pursue discovery with depositions, interrogatories, requests for documents to be able to further substantiate this standard to before it's addressed again, because summary judgment gives you the opportunity to bring out facts that aren't in the complaint, that can't be alleged yet because you don't know them because discovery hasn't occurred. So at the least, I'm going to argue we should be able to go down and readdress that in the district court.
Well, the law clinic at Stanford, is it?
Stanford, yeah.
At Stanford, if they familiarize themselves with your case, and the mere fact that the Ninth, where they argued initially in Nieves, is asking, is there any way that your case may fall under the verbiage in Nieves? The mere fact that they're asking that may excite this attorney at Stanford.
I hope so. On the other hand, though, sometimes when you're involved in an issue and the decision goes against you to a certain extent, it's traumatic, and you kind of want to distance yourself from the whole thing for a while. But this is a clinic. There are a lot of people involved in the clinic. It's not just Professor Carlin or Professor Fisher. And it's a teaching moment for students. You don't win every case, and sometimes you get a partial victory, which Nieves is. It could have been worse. It could have been a lot worse. And it leaves this exception that they've carved out. Maybe it can grow into the rule.
Into a bigger.
Because look at the exception that Scalia carved out in Heller. There's that one paragraph where he says, well, in certain circumstances, the government should be able to regulate, firearms and this and that and that and this. And the other side has taken that one exception that Justice Scalia provided in Heller and just blown it up where we can regulate firearms however we want.
And Scalia said it was okay.
Yeah, and Scalia said it was okay. And so the same thing could happen here, and let's hope for that for all our benefits. You got anything else in the draft?
Draft
brief you typed up, Ed, for the Ninth Circuit?
No, I just wanted to finish up by saying we know that there's 5 justices who agreed to Part D, the exemption. And we know that the other justices who may not have agreed with Part A, B, and C agreed with Part D, except for Justice Thomas. So I sit there and say there's 8 people out of 9 on the Supreme Court that should clearly recognize that Playford, American News Playford v. Gore, falls squarely in that exemption. These are the facts that you anticipated going down the road in the future. It's already here. Let's deal with it.
And by the way, it's coming out of the same circuit as Nieves came out of.
Exactly.
Yep.
And I'm sure that there are circuit court judges in San Francisco on the Ninth Circuit that know that the elements are there.
So do you want to move on to East Haven, Connecticut?
We can, but is there anything more pressing that we need to talk about?
We could talk about ghost guns.
We could talk about ghost guns.
Let's talk about ghost guns, because we've had a couple cases involving ghost guns, and a lot of people didn't understand them.
Right.
The law is not good for Second Amendment advocates. It places further restrictions on gun ownership, and the dichotomy between just this First and Second Amendment and Justice Thomas and Justice Sonia Sotomayor. If you're an advocate for the First Amendment, then you don't like Justice Thomas at all, and you love Justice Sotomayor, right?
Right.
If you're an advocate for the Second Amendment, then you don't like Justice Sotomayor at all, but you love Justice Thomas.
Right.
Difficult, right?
Right.
If you like the Fourth Amendment, you like Sotomayor, and you don't like Justice Thomas.
Let's talk.
So I guess you just have to weigh it all out.
Let's talk. The recently recessed state legislative session in Connecticut passed a law that prohibits "quote unquote" ghost guns.
Right.
What is a ghost gun? A ghost gun is you purchase the entire firearm in pieces from different manufacturers.
Or you make it yourself. Can't you make it yourself?
Well, I'm just going to go. You purchase it from manufacturers, and say on a Colt 1911, okay, the receiver group, the hand grip, the receiver, the trigger mechanism, does not have a serial number on the frame until it's put together and it's sold to someone. Or transferred to someone. In other words, federal law, and this is why I think this is going to get challenged. Federal law permits every non-prohibited person to manufacture, I believe, one firearm per year. You can have a lathe and machines in your basement and make the gun.
Well, not in Connecticut anymore.
Well, hold on. You're right. Now, when you make the firearm, there is no serial number on the homemade firearm. As long as you own it and you possess it, no serial number is required. If you want to transfer it to another person, either a gift or at sale, a serial number must be put onto the firearm once it leaves your control. That's federal law. You have a right to do that under federal law. Connecticut has now enacted a law that cancels out your right under federal law. And you can pass the law, you can sign it in, you can pass the legislation, you can sign it into law, but how do you take away my federal right to manufacture one firearm per year and not have to serialize it until it leaves my possession?
Well, is it a federal right? In other words, until a court determines that federal right, as you call it, is a right under the Constitution, particularly the Second Amendment, then it's okay for the state to make a law that is more strict
Well,
than that because it's not a right.
I'll
Let's
tell
take
you-
let's
I'll
take
t-
a phone call because we told people to call
Okay.
back. Oh, okay.
Good afternoon.
Good afternoon.
Where are you?
You guys are pretty good. Sounds like you guys are having a great show.
Thank you, JC.
Well, you seem to be the topic, buddy.
I told SDPD in a luncheon over 10 years ago that they need to pay attention because sooner or later, guys like me are going to overtake the entire media industry. That we will come out of, due to the internet, and here it sits.
Now,
I can't wait for the day
JC,
that there is a Nieves now in every city in America.
Right.
did you hear our phone call with Joe from Chicago?
Yeah, I'm familiar with Joe from Chicago.
He's got 4,100 subscribers already, and he only started up a couple weeks ago. Is that crazy?
Yeah, he's in a great town for it to take off. He's got great people, floating around that he's been talking to and learning from. And I think he's going to rock it.
Yeah, I think so too.
I think he is too.
Yeah.
Hold on. JC, did you take your phone to a Verizon store?
Not yet. But I'm going to here in the next day or so. I just paid out $10,000 and a bunch of shit, so I'm kind of tight.
It sounds good to me.
They'll do it for nothing, JC.
I know, but I just got to get to one now.
You've been posting a lot, huh? You've been active, very active.
Not as much as I'd like to be, but a little bit.
Hey, how do you view the verdict in the Kellen Winslow trial? He was charged with a lot. He was only convicted of, I guess, 3 things. But often
Right.
it doesn't matter. If you're convicted of anything, the judge can still send you to jail for a long time. So it seems like, the prosecution didn't get what they wanted, but on the other hand, they may have. How do you look at that?
Well, he's going to be retried on the 8 counts. Okay, I'm aware of that. As far as where he's at right now, he's looking at a maximum of 9 years.
Okay.
Which in California, that breaks down to about 4 years. I find that the DA, and you're going to love this. Watch what I do here. Okay? The judge in that case allowed news cameras from start to go in there. Okay? And in a courtroom, 2 doors down, 3 doors down, they had police officers that were on trial. And the reason they were on trial is because they got caught on camera.
Yeah.
But the judge refused to let media have cameras in the police officers' courtroom. And all of a sudden, the police officers were found not guilty. And what did I say during that hearing? Is that it looks like the DA is being soft on these cops. Is that because the limited amount of charges that they hit them with, the average citizen would have had 30 more charges on them.
Yep.
Yep.
And it's kind of odd how the one judge says, no cameras. Why? Because the cameras make sure that all the illegal shit they're doing can't happen.
Yeah,
Because if we had cameras in there, some smart son of a bitch would go, wait a minute, the judge can't do that because they saw our video.
Yeah, the prosecution controls the charges, and usually they will try to negotiate it out. They'll say, well, we won't prosecute you on this more serious charge if you take a deal on this one. And if you don't take the deal and you go to trial, then it's all piled on you. Every charge they can think of that they believe they can make any kind of case for, they're throwing it at you. So if you're going to trial and they're not throwing every charge they can at you, then yeah, you got to question why they're not doing it in that particular case.
Right. And as far as Winslow goes, I mean, this guy's had a history of being a sexual weirdo for forever. I mean, nobody wanted to be his roommate in the football league because he would sit there naked watching porn, beating off with everybody walking around him.
Now, it sounds like the jury on those 8 counts couldn't come to a unanimous decision. It was a mistrial on those 8 counts, right? They didn't come back not guilty.
Correct.
Okay. Okay, yeah.
They were deadlocked. Most of it in favor of Kellen. I mean, in favor of the prosecution. So you know it's going to be retried. Because the difference is, if he gets one more rape count on him, he's looking at life versus 9 years.
Yeah, I mean, they might deal it out. They might say, you know, you're looking at life if you get this. On the other hand, do we really want to bring back, and especially in sex assault cases, do we really want to bring back the witnesses and put them through this again? So they might try to offer them something somewhere in the middle.
There is a video. JC, let me tell the story. There is a video where J.C. Playford is attempting to question Winslow's father leaving the courthouse and asking him, do you think that this like traumatic brain injury football could have had something to do with the way your son, you know, has been acting? And a brick and mortar TV crew started yelling to Winslow's father, don't talk to him.
Really?
And JC called me up, and I've seen the video, and JC called me up, and he goes, Channel 5, was it Channel 5?
I think they're Channel 5, but we can't be 100% sure yet.
All right, well, let me put it this way.
Go down and ID the guy
Let me put it this way. If anybody at a brick and mortar station chooses to interfere with JC Playford and tell people not to talk to him, I am absolutely positive that J.C. Playford will be in an event where that TV crew is trying to interview somebody and J.C. will be screaming in their mics. You know, getting up and saying, don't talk to them, they're assholes. He'll be saying shit. Oh, yeah, they're going to have to take the guy to the station and interview him. Because that's the way J.C. Playford reacts. You screw with my ability to gather information, I'm going to come back at you.
I'm going to get them.
Right. And I
promise you.
And I fully support it if we've got him on camera, audio, telling the father not to talk to JC. Keep going. Don't talk to him.
Did he talk to you?
Oh, he threatened me.
Okay. He might have done that anyway. Who knows?
You know, he started to make him, yeah, you got to watch the video. He started to make a move. Then he backed the hell down, which is kind of funny because I can remember when all this started, Channel 5 walking with him, trying to ask him questions, keeping the camera on him, and telling, you know, Channel 5, you know, I know you're not going to answer anything, but we still got to go through all this anyway, you know. And I actually think it was a different camera crew of 5, and I'm not sure. And that's why I'm wondering if this guy's, the three of them talking about it with 5 or a different station, because you know they have so many different guys that worked at these.
You'll find out who it is.
And once I find out who they are either going to publicly apologize to me on TV, or I'm going to shut them the fuck down.
Okay, so we're gonna edit. You got anything else before we let you go?
Yes, Joe. Keep showing the heart you do. Don't back down. Make sure you're on your legal ground every time you get into a situation, and stick close to the people you trust.
Words of wisdom from J.C. Playford.
And at some point in the future, make sure you're wearing your American News hat and your American News credentials around your neck.
Yes, and I also want him to wear that little pin we got going around saying, I love J.C. Playford.
Oh, Jesus.
Bye, J.C.
Take it easy, J.C.
Bye.
You know, I'm not sure if it was on Law and Crime. It's a YouTube channel where they showed the Kellen Winslow trial, but they show so many trials on that channel, Ed. I mean, they get in everywhere. And it reminds me of the trials that we did back in, when did we do them?
January 16.
And January 17, I think?
I think so, yeah.
Maybe. And they're on our YouTube channel, and there's somebody commented a week ago. And I just happened to have this copy, you know, in case it came up today, but him talking about those trials out in California. So this is what somebody said. It's the State versus Patel trial.
Yeah.
Neeraj Patel. And this guy says, I'm pretty sure of the 1,530 views that 1,529 are mine. He says, I can watch this clown show all day, every day. What a moron. In jail for rest of his life, basically over a little weed. It's true, right?
It is.
Could have told his parents and they would have paid his legal bills. That's true, right?
Yeah.
Instead, he gets his cousin and buddy to do the robbery, and in the end, he still had to tell his parents. His cousin is a piece of work, too. I wonder if they are both in the same prison. But my favorite part's the first line. I'm pretty sure out of the 1530 views, 1520 are mine. That was entertaining.
Unbelievable.
So let me read basically it goes into effect October 1st, 2019 in Connecticut on the ghost gun issue. No person shall complete the manufacture of a firearm without subsequently obtaining a unique serial number or other mark of identification from the state police and engraving upon or permanently affixing to the firearm such serial number or other mark in a manner that conforms with the requirements imposed on licensed importers. That dog has the weirdest bark.
Now
doesn't he?
let me.
He's such a big bark, and he's such a big dog, and it's such a weak bark, isn't it?
Let me give you my opinion of this.
Okay.
Under federal law, I make a firearm, and there's no serial number on it the day I complete it, and I keep that in my possession. And I want to sell it or gift it to attorney Rachel Baird, who has a pistol permit or an eligibility certificate. Now I know that it's going to have a serial number on the firearm when that transaction takes place.
Right.
I have the right to say to you, why don't I put the serial number ATTYBAIRD 6/15/2019. That's your serial number. In other words, your name is on that firearm.
It might affect my ability to sell it, but go ahead.
It might affect your ability to sell it, but let's assume that you become a very famous person, and Van Gogh didn't get a lot of money for his paintings. Van Gogh didn't get a lot of money for his paintings.
I know.
But you find those paintings today, Jack Ruby's pistol wasn't worth shit until he shot Lee Harvey Oswald. And it's things like that. The firearm that John Wilkes Booth used to shoot President Lincoln, it was just a drop Derringer type gun. What's it worth today?
I don't know.
I don't either, and I don't care. I'm just saying, you may be affecting the sale, the retail or transfer sale value of my property by requiring me to put a serial number on the firearm at this time. Because I got to get it from the state police. I can't sit there and say, I want 2019.06.15.
I get what you're saying. I do, because within 30 days you have to do this.
Yeah.
I mean, yeah. No, I agree with that.
There's people that make knives, hunting knives and whatever. Mm-hmm. There's I'll give you an example. There's people in Japan that make samurai swords, and they are master sword makers. And they put their name on it. But what if the law said they had to put somebody else's name on it, or some identifying mark that didn't identify the manufacturer, the artist?
I got to tell you, though, some people had told me differently, but I'm reading subsection E. The provisions of this section shall not apply to the manufacture of firearms by an FFL, okay, whatever, any antique firearm, or any firearm manufactured prior to the effective date of this section, provided the firearm is otherwise lawfully possessed. So there's a grandfather clause.
Yep, so I'm going to go out and I'm going to buy 100 receivers for 1911s and have them in my possession before October 1st.
Yeah, but it has to be the firearm has to be manufactured.
The receiver group is the firearm. All of the other accessories that go with it are not the firearm.
I know, but they stuck this section in at the end, which we don't agree with. For purposes of this section, unfinished frame or lower receiver means a blank casting or machine body intended to be turned into the frame or lower receiver of a firearm with additional machining, and which has been formed or machined to the point where most major machining operations have been completed to turn the blank casting or machined body into a frame or lower receiver of firearm, even if the fire control cavity area of such blank casting or machine body is still completely solid.
No,
machined.
but let me explain.
An unfinished frame or lower receiver is not a firearm, as defined in 18 United States Code 921, subsection A, as amended.
Okay.
There's a reason
They're talking
they put that
about.
in.
They're talking about, and I remember this argument going on all the time. 80%ers. In other words, you can buy the lower for an AR-15 that doesn't have the holes drilled in it yet. It's 80% complete, but it's not 100% complete. What they're saying is even the 80%ers are going to be considered firearms. But here's what I'm going to say to you, Rachel. I believe
No. An unfinished frame or lower receiver is not a firearm. Wait.
I had to read it 3 times.
I know. It is confusing.
It's saying that an unfinished receiver is considered a firearm.
I don't know about that.
Okay, well, let me put it this way. I believe that the lower receiver of a Colt 1911
I think
semi-automatic pistol is the firearm, not the grips, not the pistol, the trigger mechanisms, not the bolt, not the barrel, not the upper slide, not the safety stick, whatever. That's not the firearm. The firearm, and they're kind of saying this is what it is. The other parts aren't.
Mm-hmm.
Yep.
So that goes into effect October 1st, 2019.
Now, here's my problem. I own property in Connecticut. I own property in Florida. I own property in California. In Florida, I can build and possess a ghost gun.
Right.
I can't bring it to Connecticut?
No, you can. It's like
Like the AR?
It's like assault weapons and stuff. Different states, and it all getting back to Heller versus District of Columbia. It all emanates from that one little phrase in the decision by Justice Scalia. The exception to the rule has become and swallowed the actual rule. Let me see if I can find that terrible part.
My president.
Oh, yeah, let's talk about Donald Trump.
My president hopefully will have the opportunity to place another individual on the Supreme Court. And I believe that some of those fingernail holding on people who just went to that little section of Scalia may have to swallow their decisions.
Yeah, but what effect will that have on the First Amendment? Justice Kavanaugh was no friend of the First Amendment in Nieves versus Bartlett. Justice Gorsuch was.
I have to tell you something. I have to tell you something. I've said repeatedly on this program, on this show, that I never went out looking for trouble. I never went out looking for a confrontation. I never went out to do what's called the audit, so to speak. I support the people who do.
Well, but they don't go out looking for trouble.
No. I understand that.
They're holding government accountable.
Listen, I understand that. And I support them doing it. I don't. Because I believe that there's enough incidents out there that could be recorded And if they come up to you and they give you shit and there's a legitimate incident taking place in your view, that you should be able to fight tooth and nail to stand your ground. But I can understand where, this was a bad case. Bartlett was allegedly intoxicated. It was a volatile situation in the Arctic Man Festival. There were supposedly other people that were acting out and being boisterous and doing whatever. It was like that, yeah.
Well, let's describe how it got up there. It got up there because in the district court in Alaska, the district court found in favor of the officers and threw the case out on summary judgment.
Yep.
Bartlett lost. Bartlett appealed it to the Ninth Circuit.
Just like I did.
Right. And he won. Right?
I didn't.
And
I did in the first round.
You did. And then the state of Alaska appealed it to the Supreme Court, probably because they believed they could win. If they didn't believe they could win, then they wouldn't have done it. They just would have let it lie in the Ninth Circuit like that. Bartlett didn't have a choice whether he was going to go up to the Supreme Court. I'm wondering if Bartlett would have lost in the Ninth Circuit, if Professor Carlin or Professor Fisher at the Stanford Supreme Court litigation
would have wanted to take it up.
Would have wanted to take it up. I bet they wouldn't have. I bet they would have wanted to wait for a better case on the facts to take up to the Supreme Court for this First Amendment principle. But they had no choice. They had no choice. Somebody had to get in there and stand up for the First Amendment the best they could on this case that Justice Ginsburg calls a thin case. And so it was very difficult. And it's a shame that it worked out this way. Wow. It's a shame. It's good for the other side, but it's definitely a shame on this case. I think we've talked about everything we could talk about today. You know what though? Since we have 15 minutes and Nieves versus Bartlett is such a big case, do you want to hang on for another 15, or you want to close the show up now? You want to close the show up now? We're going to close the show up. I want to thank everybody for joining us. We've been gone for a couple weeks.
Congratulations to Joe in Chicago.
And congratulations to you, Ed, for 30 years of American News and Information Services. It really is. It was
been a long road.
It was earlier this month, and I said to myself, wow, I know that American News was incorporated in 1989. I hope that the actual date of incorporation hasn't passed. And so we have the Secretary of State's website here in Connecticut that has Concord, where you can look up businesses and all that. So I looked up the business, and sure enough, it said June 12th was the incorporation date, and it was before that. So we had time to get our poster up in the front window.
Officer Joseph Dwyer.
Joseph Dwyer. You want to tell the story?
Here's the story.
Here we go.
I'm shooting video in the city of Hartford.
Right.
There's a minority section of Hartford referred to as the North End. In the North End, there is a road called Tower Avenue. On Tower Avenue, they have various townhouse-style apartments, condos, whatever. And a female has an argument with her boyfriend, and the boyfriend charges out the door and says, I'm leaving, and gets in his car. And as she's going into the car, the lady goes, and you ain't coming back. And she closes the door and does the deadbolt. Half an hour later, the guy doesn't have a place to go, so he comes back to the house. He says, let me in. She says, nope, you left. You're done. Out of here. See you later. And the guy drove his car through the front picture window wall of the condo or apartment into the living room. And the hot water pipes, it was wintertime, and the hot water's going up and there's steam all over the place. And I get a call. I hear the call, car into a building. So I drive up. It's probably 1 o'clock, 2 o'clock in the morning. And I drive up, get out of my car, put my hat on, put my media credentials on, got a camera on my shoulder, and I start video recording. And this Hartford police officer comes up to me and says, who the fuck are you? Who are you?
What time of the day was this?
2 o'clock in the morning.
Okay.
Who are you? I said, I'm Ed Peruta from American News. What do you mean American News? What are you doing here? And I said, I'm the news media. And Joe Dwyer said to me, he grabbed my credentials off my chest, and he's looking at him, and he goes, news media, you're full of shit. You're just an asshole. You're an asshole, and you're full of shit. And I was pissed, and I called the station, and then the on-duty deputy, captain I guess he was at the time, comes out. Well, the captain that came out was a rookie on Hartford when I was a rookie on Wethersfield. We used to drink coffee together. So he knew who I was. He knows what I do. And he says to me, Eddie, I want you to give me paper on this guy. Meaning I want you to make a complaint. I said, no. Tim, I'm not making any complaints. I said, you need to address this. He says, if anybody can get him fired, you can. He says, I want you to give me a complaint. I said, nope, not going to do it, Tim. So we walk away. At around the same time, it had to be in 1989, I was running under the name Connecticut News Service, CNS. Joe could be Chicago News Service, Houston News Service, San Diego News Service. But I was running under Connecticut News Service. The marker plate on my truck was CNS1.
So when Dwyer took it off of you, it must have said Connecticut News
did.
Service,
It
not
did.
American News.
No, it said,
okay.
it said Connecticut News Service. And I had fire line passes and National Press Photographers IDs and all kinds of shit. So, there was a guy working at the state capitol named Joe Valvo. And Joe Valvo owned a news service called Capitol News Service, CNS.
Okay.
So evidently everybody was going up to Joe Valvo complaining about the guy CNS1 who they thought worked for Joe Valvo and creating all of the shit out in the towns with the cops. So Joe Valvo calls me up and mandates that I change the name of my company. I said, who the fuck are you? He says, no. You're interfering with my ability to function up here at the Capitol because people are confusing Connecticut News Service with Capitol News Service. And I said, well, too fucking bad. See you later. Well, shame on me. He was able to go down to a local town hall and registered the DBA, doing business as Connecticut News Service. So I could no longer use that, and I wasn't incorporated. I could no longer say I was Connecticut News Service because he owned Connecticut News Service.
But what town hall did he register in?
The town I live in.
Oh.
Rocky Hill.
Okay.
So, I had a lawyer at the time, and she told me, Ed, you need to change the name of the company. I said, no, I ain't changing the name. I said, I'll fight his ass. And she said, Ed, it's not worth it. The return is not worth the expense and time in fighting to keep it again. Just think of something else.
Good advice from a lawyer.
Now, at the time, I'm flying all over the world on TWA. My wife is a flight attendant. I was riding with her, and I was in England, Greece, Italy, Cairo, Hawaii, all kinds of places. And so I sat there and I said, this is something that I'll tell anybody that's going to get involved in News Now this or whatever. I said the name that I have to come up with has to say who I am, what I do, and where I do it. And I don't want to be in London, England, saying I'm the Hartford News Service or the Dallas News Service or the Podunk News Service. I said, because I was also shooting video overseas. So I sat there and I said, I'm American, and I'm news service. But then you have to understand that people come to you and ask you to acquire government documents for them, and they don't want the government to know that they're the ones that asked for it. So they would come to me and say, Eddie, can you go into whatever town hall and pick up some records for me? So I said, okay. So I would go in and I would ask as American News, or I would ask as Ed Peruta. So I said, and not only do I do the news, but I'm also involved in acquiring information for people. So I said, American News and Information Services. That is who I am, what I do, and where I do it. And then it jumped off the page at me. Oh boy, that's anus. Huh? I'm going to go with anus. Now, so I walk up to the lawyer and I said, I got the name. She says, what's that? I said, anus. American News and Information Service. She says, you came up with that too fast. She says, how long have you been thinking about this? I said, about a week and a half. I've been putting it together. And so I said, Joe Dwyer told me that I was an asshole and I'm full of shit. Well, that's an anus. So I named my organization American News and Information Services, Inc. I incorporated it. I own it. It was done on June 12th, 1989, and I've been anus ever since. And you know something? There's still a lot of people that think that I'm an asshole and I'm full of shit.
And then when we're involved in litigation and the other side notices that, I guess. Because,
they do.
Because you put
Terry O'Neill.
You put the full name out there and then you abbreviate it when you keep going further on whatever document you're filing. And so they'll put ANIS in capital letters as if they're the first one to think of that, and they enjoy putting that in there and
they actually say
it with
things to me.
Right.
You do realize that American News is the acronym is ANUS. And I look at him, I go, do you think I didn't fucking know that when I did it?
And you'll notice that in any briefs I write, which refer to American News, I refer to it as American News. I will not use that term in a legal brief. And I know you enjoy that story, but yeah.
Well, there's a lot of people out there that are doing news now, whatever, that will probably enjoy this story too, because I'm sure there's a lot of cops out there telling people with cell phones that they're an asshole and they're full of shit.
You know, which reminds me of, we got a comment. Remember that ADA video we did outside the Milford Courthouse?
Yes.
After you were unable to get into the bathroom or something? Somebody commented on that 3 weeks ago. They said, this video ends with the words, it's bullshit. Oddly enough, that describes government, period. And that's the way you ended that video. All right,
we're done.
Okay.
Time to call it a week, call it a day, and see you next week.
Cue the closing for real this time. See everybody next week.
There you go.